Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello, and welcome to the 5th episode in our podcast series about artificial intelligence and legal professional privilege, where we discuss the impact of AI on this privilege and on litigation more broadly. I'm Lauren Saparovich, Special Counsel at Hall & Wilcox, and I'm delighted to be your host for today's episode. For those who've tuned into previous episodes in this series, my colleague Katie Moore and I have discussed the topical and evolving effect of AI on legal professional privilege. In our last 2 episodes, I spoke with a former colleague at English firm Mills & Reeve to compare the position between Australia as well as the UK's approach to this topic. In today's episode, we will be discussing how AI is impacting legal professional privilege and litigation, but focusing on how this issue is being approached in the United States, including as compared with the position in Australia. To do so, I have a very special guest with me here today. I have the pleasure of speaking with Ian Clark-Fisher, partner from Robinson & Cole in the United States. Ian joins us from the New York office of Robinson & Cole, and I had the pleasure of meeting Ian at a recent conference in Melbourne. Welcome, Ian. Thank you very much for speaking with me today.
Yes, good morning, or good afternoon, good evening.
Good evening.
It's a pleasure to be with you. Yeah, as you mentioned, I'm a partner at Robinson & Cole. I'm based in our New York office. And Robinson & Cole, just for those that don't know and that are listening, we're a full-service firm with about 300 attorneys spanning along the East Coast of the United States. And yeah, it's a pleasure to be on.
Thank you, Ian. And I understand that rather than being in New York today, you're joining us from Maine. So thank you very much for making the time. And I'm sure we all in cold Australia at the moment wish we were in warm, lovely Maine. So thank you for speaking to us. So to dive right in, as we've discussed between us, Ian, AI really is transforming the way that we work as litigators. And really the speed and pace of change is huge and ever changing. The judiciary and regulators in Australia are really only starting to consider the impact of AI on litigation, including its effect on legal professional privilege and client confidentiality. So I'm really pleased to be exploring with you the events that are occurring currently in the United States, especially considering the comparative fast rate of consideration of these issues in the American courts. So today we're going to discuss a number of significant cases in which the courts in the US have started to grapple with the effect of AI on privilege. But before we do that, Ian, can I ask your thoughts on the use of AI in practice in the US? And I know that's a very broad question, but I think people would be interested to know how it's being used and portrayed in litigation and day-to-day process.
Yeah, absolutely. And I think, as you mentioned, we met in Melbourne when I had the opportunity to go down there, and I was speaking on a
Yes.
panel, and I brought up this issue of AI and its kind of ever expanding role in the practice of law. And it's one of those things that I think over the last year, it is really AI is everywhere, right? It's in the practice of law, but it's also in practical life. Everyone is using AI. It's unavoidable. Our clients are using it, our adversaries are using it, right? Third parties are using it. And so it's only natural that it becomes that case law begins to develop about how it interacts with the actual practice of law. It really, my opinion, moved from theory to where we are right now, which is that I think, the expectation is that most lawyers and law firms are at least using some form of AI in their day-to-day practice. And I may be mistaken about that, but I do feel like as time progresses, it really seems to be everywhere. And in thinking about this conversation where we are really talking about the initial phase of AI, right? And
Yes.
this is really this is the beginning. And this conversation, I hope it won't, but this conversation may feel dated almost by the time we're done recording, in the sense of how quickly things are developing. But it feels somewhat similar to the discussion about ESI, or electronically stored information, that when not that I've been practicing forever, 15 years ago or more, when I started doing civil litigation, that was a big topic when you would start a case and you're speaking with your adversary and you have to have an ESI protocol, and people would reference the Sedona principles and things like that. It was this Whereas now that's standard practice. No one is thinking about it in that way. And I do feel like this discussion about AI is probably going to develop similarly, where it's a big focus right now. It needs to be a big focus right now. There's obviously a great deal of thought that needs to be put into it, but I do think that over time, and probably more in the short term, it's going to be something that's just part of the practice, right? It's inevitable.
I agree. And I definitely agree with you. And it's really interesting. I'm not sure if you've seen, but just a couple of days ago, the UK, just to switch jurisdictions here, a jurisdiction task force in the UK actually went and moved the dial even further in that they have determined that practitioners can be liable for failing to use AI for a task where reasonable care and skill would have allowed it to do so. So I think that's a very interesting step in that we're still in a world where we have a lot of uncertainty about the use of AI in litigation, but then we've got jurisdictions starting to emerge, or at least commentary or guidance starting to emerge, where if you don't use it, you're damned if you do, damned if you don't. So we are in this really interesting precipice time where things can move either way and be quite hard for one to navigate in this early period, or relatively early period rather.
Yeah, that's so interesting. I have been thinking about that, the idea that, at a future date, what's going to be the professional standard will be that you are required to use AI, and that it's
Mm.
almost tantamount to malpractice if you're not using AI, because how could you turn a blind eye to this kind of incredible tool, especially in the context of litigation where, if you're against another firm, odds are they are also going to be using this tool. And as we see when we're talking about the cases, everyone is thinking of it as a tool, but it is an incredible tool. And the idea of kind of not using it is almost more concerning than using it at this point.
Exactly. But then I think that begs to question exactly what we're here to talk about today, is that it needs to be used and it should be used, and it can create a litany of efficiencies for clients and for practitioners. But to misuse it or to use it in a way that doesn't adhere with professional obligations and professional expectations is to completely go backwards in every way, shape, or form in terms of your professional obligation. So it does really come down to understanding the use and how we can use AI with respect to things like maintaining privilege and maintaining confidentiality. And that's why I think it's so interesting to have a look at this case law and this various guidance across the jurisdictions, because we're in a realm where, as you've said, it's almost going to be tantamount to malpractice eventually, perhaps, if we don't use it. But then the courts and the guidance that's being released by these entities is still not completely aligned as to how one should use it. So it's very interesting how this moves. And I think, as we'll come to, I definitely think the US is more advanced in that discussion in different ways.
I think there is, when you say advanced, I think there's, as we'll discuss, there are cases, but I think in 6 months, I think there'll be more of a standard than there really is right now. I think we're really in the infancy
Of
of
course,
case
of
law.
course. And as we'll discuss, to my understanding, and please, I look forward to you explaining the situation to me, but my understanding is that there's been a lot more case law in the US, but there actually has been pretty significant court guidance and court jurisdiction and judicial guidance in Australia. So it's not that there hasn't been any progression, it's just it looks quite different between the two jurisdictions, but we'll get to that. So on that point, I think it might just be good, and I think I'd really like to hear about legal professional privilege and just that core process and that core basis of our discussion, because as I understand it, and as we all understand it, it's really an essential safeguard in the legal system that applies both in the US and Australia. And the maintenance of client confidentiality really is a fundamental duty, as we know, of the professional standards for both American and Australian solicitors. So obviously it looks ever so slightly different between our various jurisdictions. So Ian, can I trouble you to explain attorney-client privilege and work product doctrine under the US law and that the privilege that is in the US, please?
Yeah, and again, this is just a general, broad
course.
concept. But yeah, the attorney-client privilege, and I expect it's likely somewhat similar in Australia, although I don't know. But the attorney-client privilege is, and I believe that it's the oldest recognized privilege in American jurisprudence. And the purpose is really to allow for a for a fulsome and candid conversation between a client and their attorney. It's really fundamental to an effective representation. What the attorney-client privilege does is it protects confidential communications between a client and their attorney, and this is important, made for the purpose of obtaining or providing legal advice.
That's very similar. Ours is for the dominant purpose of legal advice or use in current or anticipated litigation. So dominant,
Right.
ours, we've added in the word dominant.
And right, ostensibly what it does is it protects communications with counsel. What it doesn't protect are facts. And I always think that this is whenever there is a discovery dispute about what's privileged and what's not, it, in my experience, largely hinges on whether the communication is just relaying standard facts, right? You can't shield facts from disclosure by just providing them to your attorney. And the other element is that, and I think this is important for the context of our discussion, is that the conversation must be confidential and with your attorney. That is no third parties. Now, there could be consultants and kind of retained parties that are part of the litigation. But as a practical matter, the safest bet is really the conversation is between a client and the attorney. And really, the attorney-client privilege is a narrow exception and really one that's just for the purpose of obtaining legal advice. And tethered to the attorney-client privilege is the work product doctrine, which at least in America, in my opinion, and we'll talk about this a little bit about, there's all sorts of courts and all sorts of different rules, but the work product doctrine is a little more amorphous, right? It's a, in my opinion, it's more of it's a vaguer doctrine. And what it protects are documents that are prepared in anticipation of litigation. And those documents arguably can be prepared by a party or its representatives. So it's not necessarily just prepared by an attorney. Now,
And that will
similar
become
to
very key in our discussion to follow.
exactly. But similar to the attorney-client privilege, it doesn't protect facts, but it does protect opinions, strategies, things like that, which then gets to the point, and this is one of those, as a litigator, anything in writing at a certain point begins to make me nervous, right? But there's, with both of these rules, there is these are general rules where the devil is truly in the details, right? And when if there's what in the States is called an in-camera review, right? But if the court is looking at the documents to make a determination as to whether it should be disclosed to the other side and whether it is indeed protected by the attorney-client privilege or the work product doctrine. In my experience while there are legal arguments and there are factual arguments, a lot of it depends, and this is what we'll see with our discussion, right? But a lot of it depends on how the court is viewing things.
Yes, of course. And that nuance really is borne out again in the cases and some of the discussions we've had. And I actually think, and we'll come to this, but I actually think the courts have started doing a relatively nuanced job of taking those considerations into account in how they affect and form their views. So obviously that could be even more significant as we go, but at the moment, I think that has been taken into consideration as far as my understanding of the cases. And as you've said, in Australia, it's quite a similar position in Australia. As you said, it's quite a common sort of privileged position. But as I explained, we have two forms of privilege, but again, for this dominant purpose. So that's really the test in Australia. And the first being legal advice privilege. That protects confidential communications made for the, again, dominant purpose of giving or receiving legal advice. And then the other, being more closely akin, I think, to your work product doctrine, is litigation privilege, which applies when litigation is underway or anticipated. So that's quite key for us in Australia. The anticipation of litigation makes that have quite a long tail attached to that privilege, and it protects confidential communications, again, made for the dominant purpose of preparing or conducting that litigation. And those forms are both enshrined in both state and federal legislation, as well as in common law in Australia.
Right. So again, it sounds like it's a very, very similar standard, right?
Yes.
Saying the work product doctrine absolutely has to be prepared in anticipation of litigation, as opposed to just notes to self.
Yeah. Yes, exactly. So then if we're really thinking it from a sort of black letter of the law perspective, if we're thinking about it in the use of AI, disclosure really to a third-party server can easily waive legal professional privilege if it results in the dissemination of information or the undermining of the confidentiality of a document or communication. And I think, and this is something that's really been reinforced in Australian guidance, but the risk of a waiver is really compounded by the functionality of these generative, either public or open AI tools. And publicly available AI tools, such as the one that we all know best, ChatGPT, contains terms of use that grant the platform quite broad rights over user inputs. And if confidential client information or material is uploaded, it, as we know, it can be retained on third-party servers and potentially exposed through later investigations by other users, system vulnerabilities, data breaches, that sort of thing. So this loss of control over the information is causing a lot of discussion in Australia and is fundamentally inconsistent with the maintenance of legal professional privilege. And there's a lot of discussion in Australia about the differential between open and closed AI for those reasons. So theoretically, the concern can be addressed by the use of a legally focused closed data set AI rather than those that are publicly available. But then that begs the question of how closed is a closed system, and that's something else that's been discussed in a bit in the US decisions. But what Australian courts and judiciary and guidance has tried to do is provide some terminology around public or open AI as compared to closed AI, just to try to rein this sort of differential in a bit. And just to set the scene a bit, I might explain that public or open AI is defined for us in various practice notes and also in some Law Reform Commission reports that have been released. Quite a lot has been released this year on this topic, and they've all adopted similar definitions that public or open AI are AI tools that are openly accessible to the public, typically via the internet, and they're trained on broad, often public data sets, most commonly for general purpose use. So quite obvious. Whereas closed AI is generally not openly accessible to the public, and information used in those tools remains typically within a controlled environment. When an AI tool is closed, there are controls to reduce risks related to privacy or confidentiality settings that protect information from being made publicly available or used to train the AI tool. So that's kind of the broad framework that we in Australia have adopted loosely within a couple of the courts, both at federal and state level. And also at our various commissions and regulatory bodies have adopted a similar sort of definition to try to put some terms in place that everyone could adhere to. Do you have a similar sort of understanding of the difference between open and closed? Is there a similar sort of delineation or definition in the US regarding public or open as compared to closed, Ian?
Yeah, and I don't know that at least not at this stage, that the courts have defined it that specifically. So that guidance is actually pretty helpful. I'm a bit of a Luddite, but I'm almost thinking of it as closed AI is AI that you're paying for, right? That as a practical matter,
Or someone is paying for.
Fair, yes, exactly. Whereas kind of the open AI is the free Chat GPT or Claude or things like that, where they're not subject to any contractual relationship. But yeah, I mean, I think as a general matter, the definitions are the same.
Sure, and I think, as we've spoken about, I think the courts and the further decisions that are made in this space will help tease out what actually in practical use is defined as closed or sufficiently open to warrant criticism or otherwise. And I think this might be back into this watch this space kind of situation with the definitions. But interestingly, I think with these definitions and our discussion of privilege in the back of our mind, I would be really interested to turn to some of the decisions that we've been foreshadowing, specifically the really significant judicial consideration of these issues in the first half of this year so far. And there's been a lot of movement in the US in this space. But before we turn to consider the many cases that have passed, of which we'll touch on the main few, may I trouble you, Ian, to explain sort of first principles? I think people would be very interested to know something that you foreshadowed earlier, is that the disparate and the many different sort of procedures and structures within the United States legal system and the US judiciary, as between the states, as between federal versus state. Can you give us a little bit of a background? I know this is a very big question, but a bit of background to set up the position in the US and the judiciary?
No, yeah, absolutely. America is a large country. We have both a federal and state court practice. There are 50 states, which means different sets of laws, although there's a great deal of overlap between state laws. They really are all varied. And then from a federal perspective, there are, I believe, over 90 federal districts, which all go
Mm,
up to 12 appellate courts. So there's different state and federal law, which means that the practices, the rules, even the ethical obligations can vary based on where you are. For example, not that to confusion here, but my practice, although I'm seated in New York, I'm admitted to practice in Connecticut and Massachusetts. And so those practices vary, the rules vary between all those jurisdictions. And then adding to that, and I don't know if this is similar or different in Australia, but in my experience, a lot of judges and courts, county courts, they have their own individual practices, right?
okay.
From a practical standpoint, you really have to look at once you're in litigation, who's the decision maker and what rules that decision maker has. If there are any standing orders or individual practices. So it is there's a while there are general themes, there is a lot of differentiation.
That seems similar in some ways and quite different in others, in that, as you've expressed about being admitted in two different jurisdictions, I too am admitted. I'm admitted in both Western Australia and Victoria, so two states within Australia, and there are many similarities, but there are also quite significant differences of state legislation that's relied upon between the two. But obviously then they have the overarching federal legislation that applies to all, but state by state, they differ extensively.
Right.
But no, we definitely do not have 94 federal districts. Not at all. So it's very interesting. I must confess, how do you keep track of everything? Or is it a matter of having to become does that allow then one to become quite specialist in your space? Or is it that you still have to, as particularly as a litigator, keep your finger in many pies in that regard? I'm just interested from a personal perspective.
Sure. I think as a practical matter, when you're in a jurisdiction that you don't practice in routinely, my recommendation is always get local counsel.
Of course, of course.
Get someone that knows the ins and outs of that court, because yeah, again, there's also the practice as written versus
Of course.
the actual
colloquialisms as well.
practice. Yeah, so it's, if you can read the rules all you want, but unless you're actually utilizing the rules, you really don't know what you don't know.
No, and that's again the same as between the states and territories in Australia. Very much defer to the locals. No, that's wonderful. So with that, thank you for setting the scene in that regard. So that will help us somewhat understand the varying different decisions that come out of the different states, because there has been a lot of divergence between the states and quite a few different decisions around from the different states in the US. So I understand that a lot happened starting from February of this year, in which within the space of about a week or so in February, we had two federal courts in the United States issue quite significantly different rulings on the impact of AI and the AI use on legal professional privilege. Now, albeit, which we'll come to discuss, they're different factual matrix, different considerations, but it's very interesting to see two quite disparate decisions come out about similar sort of uses and similar issues within a short period of time. So it's interesting to me that the growing body of case law in the US does appear to illustrate differing approaches to how courts characterize the AI use. And it's, as we'll come to discuss, some courts treat AI platforms as third parties capable of breaking confidentiality, while others seem to view AI tools as tools specifically analogous to more traditional litigation aids. And the latter really, as you and I have discussed, Ian, is very significant for people like you and I who practice in this space every day. So on that note, can we first discuss what I really understand to be the catalyst case that began a lot of discussions about the use of AI and its effect on privilege, and that's United States and Hepner.
Yeah,
What are
absolutely.
your
I mean,
thoughts about that case? Yes, please.
right. And this was actually, I think this is what started your and my conversation, because I brought up this case when I think I was in
Yes.
Australia in March, and it was this was recent news. But this is really the front runner case, right? This is a Southern District of New York case. So This is federal court in New York, a very active courthouse. And this is a decision which is really a case of first impression where the court found, and this was in response to an individual being subject to a federal grand jury criminal investigation. The individual used a public AI platform, Claude,
God, yes.
and the court, in a fairly detailed analysis, found that there was, and this individual was represented by an attorney, but the court found that the individual's use of Claude was not protected by the attorney client privilege because Claude was a public AI platform. There was no expectation of confidentiality. And also, his attorney did not direct him to use Claude. So it wasn't his counsel's direction. And the court, and this is interesting for our discussion, the court also found that this use of Claude was not protected by the work product doctrine. Now, I think maybe importantly, maybe not, that this is a criminal case, which is governed by criminal procedure, which candidly, I don't practice criminal law, but so it's different from standard civil procedure. And also, I think this case can be viewed as a very fact specific case because, as we'll get to, the general premise of the work product doctrine not applying to the use of AI seemingly hasn't been adopted by other courts in the US going forward. Not to bury the lead there, but
no, of course. I think your point about the Heppner having counsel, I think is very significant, and that's something that has manifested and grown in subsequent discussions about self-represented litigants and how they act as their own counsel and the like. And again, not to foreshadow what we're going to discuss, but in this specific instance, the court did comment that had counsel directed Heppner to use Claude, it might then be arguable that Claude had been the AI tool here was functioning in a matter akin to a professional acting as a lawyer's agent, and then therefore that might fall under the banner and the protection of attorney-client privilege. So it'd be very interesting to think how this decision may have differed if the factual matrix were ever so slightly different, hence to your point, Ian, that in this case it's very fact-specific. And I think the way that the subsequent cases have been decided, and again, not to jump too far ahead, but there is quite a delineation between the AI tool's use and whether it falls within acting, the extension of acting as your own legal professional or preparing work as a legal professional. And I do wonder whether Heppner, if viewed in that quite narrow lens, still does fall into the same sort of line of thinking, insofar as the court did open the door to allow for, perhaps we would have decided differently had this person actually acted on behalf of their counsel or at the direction of counsel rather than as a renegade in this instance in a fraud proceeding.
Yeah, it certainly falls in the category of when you have the facts, argue the facts, and when you have the law, argue the law. I do think that this case can be viewed as a factually specific case.
Yes.
And I think that other courts are viewing it that way. Granted, it's not really, it's a trial level decision. It's not binding. And I think I should, just to get ahead of it, as far as I'm aware, there's been no appellate level decision in the US on privilege and AI.
I don't think so either. No.
Right. So everything that we're discussing here is that the courts are taking this, all these courts, while it may not be in the first instance outside of Heppner, they're all taking this as their own analysis as opposed to being governed by any true principles or any appellate decision.
Yes, and you're right. It will be very interesting to watch what sneaks through to the next round, if you will, to use very vague and tangential World Cup references. Who gets through to the next sort of round of play in terms of which line of thinking is then adopted at a higher level? That will be very interesting to see because, yes, at the moment it hasn't gone further in that regard. But I do think with respect to Heppner, it is quite interesting, even if it's just as a point of comparison for our further discussions, Ian, to note that the court viewed, as you've foreshadowed, that the material that the defendant had disclosed in this instance, the material to a third party. So here the AI was considered the third party, which will be very interesting in terms of how other courts later this year and between February when Heppner was decided and currently how they've seen the AI tools, because that's not necessarily consistent with how other courts have viewed the AI tools in other factual situations.
No, exactly. Yeah, I think that as we'll discuss, I think we're probably about to get to the next case. But I mean, I think the majority of decisions now have viewed things somewhat differently.
Thank you, everyone, for listening to part 1 of this episode, in which we discuss how AI is affecting litigation, including its impact on legal professional privilege in the United States and the comparison to its effect in Australia. In this part 1, I spoke to Ian Clark-Fisher of Robinson & Cole to understand this privilege in the US and how it does compare to Australia, as well as for Ian to set the scene with first principles of the judicial system in the US and launch into a consideration of the catalyst case of United States and Heppner. As we heard, Heppner really set the scene for the courts to consider AI use in litigation and its effect on privilege. Part 2 of my discussion with Ian will unpack a number of key cases that have been decided subsequent to Heppner, and to understand what extent the post-Heppner decisions diverge and consider the nuance of the use of AI in practice. We will also consider the differences and similarities with the current landscape in Australia, as well as to discuss what's worrying litigators when it comes to AI and privilege, as well as some key takeaways to consider when using AI. As always, please get in touch with me if you have any questions about what we have discussed. You can find my details on our website, which is hallandwoolcock.com.au, or connect with me on LinkedIn. If you've enjoyed today's episode, then rate, review, or subscribe wherever you get your podcasts. Thank you, and tune in to part 2 of our discussion regarding the law in US and Australia. Coming soon.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.